You. Yes, you. This is about your bank account and the agreement you have made. And what I am about to tell you affects every single penny you have ever saved, earned, or deposited in your entire life. This is not general information. This is about your money, your account, your name on that contract. Let us begin. Think about the last time you signed a bank contract. Maybe it was when you opened your account. Maybe it was when you took a loan. Maybe it was when you got your credit card. Do you remember reading it? Not skimming it, not scrolling past it, actually reading it. Every single word. If you are being honest with yourself, the answer is no. And that is exactly what your bankie's counting on. Because buried inside that document, the one you signed without reading, is a clause. Not just one clause. Several. And these clauses do not protect you. They were never written to protect you. They were written by teams of lawyers, whose only job was to make sure that no matter what happens, the bank wins, and you, the person whose money is sitting in that account, you are left with almost no legal ground to stand on. Today we are going to read that contract for you. We are going to pull out the clauses your bank buries on page 14, page 22, page 31, the pages they know you will never reach. Stay with me, because what comes next is something your bank has spent millions of dollars hoping you never find out. Let us start with a question that sounds simple, but has a deeply uncomfortable answer. When you deposit money into your bank, whose money is it? Yours, right? You earned it. You deposited it. It has your name on the account. It must be yours, except legally it is not. The moment your money crosses the threshold of that bank deposit, it stops being your money. It becomes the bank's money. You become what is legally called an unsecured creditor. Let that sink in for a moment. You, the person who worked for that money, are now a creditor of your own bank. You are essentially lending your money to the bank and trusting that they will give it back when you ask. This is not a conspiracy theory. This is established banking law recognized in the United States, the United Kingdom, the European Union, and most financial jurisdictions worldwide. The landmark legal case that confirmed this was Foley versus Hill, decided in 1848. The House of Lords ruled explicitly that when a customer deposits money into a bank, the money becomes the property of the bank. The customer's only right is to demand an equivalent sum back, not the same notes, not the same coins, an equivalent amount. And here is the terrifying part. That ruling has never been overturned. It has been quietly referenced in banking regulations ever since, and it is the legal foundation upon which every bank contract you have ever signed was built. So when you signed that document without reading it, you agreed to this arrangement. You handed your money to the bank. You became their creditor, and you trusted a system that was legally designed from the very beginning to favor the institution over the individual. Now let us open that contract and look at exactly what you agreed to. Clause 1, the right of offset. This clause appears in almost every bank agreement on earth. In plain language, it means this: if you owe your bank money on a loan, a credit card, an overdraft, they can reach directly into your savings account, your salary account, even your children's account if it is linked, and take what they believe you owe them, without calling you first, without sending you a letter first, without giving you any warning whatsoever. You could wake up tomorrow morning, check your account, and find it empty, legally. Completely empty, and your bank will point to page 14 of the agreement you signed and say, you agreed to this. This has happened to real people. In 2010, a woman in Ohio had her entire salary account swept clean by her bank to cover a credit card debt she was actively disputing. She had no warning. She could not pay her rent. She could not buy groceries. The courts largely sided with the bank. Clause 2, the variation clause. This one is perhaps the most quietly dangerous clause in your entire agreement. Your bank can change the rules of your account. Whenever they want, they can raise your fees, they can lower your interest rate, they can add new charges, they can change withdrawal limits, they can alter overdraft terms, and their legal obligation to inform you is satisfied by sending you an email. An email that goes to the same inbox where you receive promotional offers, shipping confirmations, and newsletters you never subscribe to. An email specifically designed to look unimportant so that you delete it without reading it. And once that email is sent, the bank has fulfilled its legal obligation. The new terms apply, and you who deleted the email are bound by rules you never actually read. Clause 3. Account suspension and termination. This clause gives your bank the right to freeze or close your account at their sole discretion for reasons described as suspicious activity. What counts as suspicious? The definition is deliberately broad. Banks have frozen accounts for receiving an unusually large transfer, even from a legitimate employer bonus, making purchases in a foreign country, even while on a trip you informed them about, withdrawing cash in amounts the bank considers unusual. Even if it is your own money for a completely legal purpose, the account can be frozen immediately, without your consent, without a court order in many cases. Your salary may be held, your mortgage payment may bounce, your direct debits may fail, resulting in penalty charges from other institutions for something entirely outside your control, and your bank is legally protected by the clause you signed that gave them this power. Clause 4. Force majeure and systemic risk. This is the clause most people have never heard of, and the one that matters most in a genuine financial crisis. Hidden deep in most banking agreements is language protecting the bank in the event of economic instability, government directive, systemic financial risk, or circumstances beyond the bank's control. In plain language, if the financial system comes under severe stress, your bank has legal cover to restrict your access to your own money. This is not theoretical. In Cyprus in 2013, the government and the European Central Bank forced banks to freeze accounts and impose withdrawal limits overnight. Citizens woke up unable to access savings, and then in what became known as a bail-in deposits, above 100,000 euros were simply confiscated to recapitalize the failing banks. Not borrowed, not temporarily held, taken, permanently, and it was legal, because depositors are unsecured creditors of the bank. In a bankruptcy or restructuring, unsecured creditors are last in line. The bank's bondholders get paid first. The bank's secured creditors get paid second. You, the ordinary person with a savings account, get whatever is left, which in Cyprus, for many people, was nothing. In 2010, the United States passed the Dodd-Frank Wall Street Reform Act. Buried inside it is a provision legally establishing the bail-in framework for American banks. If a major American bank faces collapse, the law allows the bank to be recapitalized using depositor funds before any taxpayer bailout is triggered. The FDIC insures deposits up to $250,000, but the FDIC reserve fund holds enough to cover approximately 1.3% of all insured deposits. 1.3%. In a systemic crisis where multiple large institutions fail simultaneously, that fund would be exhausted almost immediately. This is the architecture of the system as it exists today. Documented, publicly available, almost never discussed. So where does this leave you? This video is not about fear. It is not about pulling your money out of banks and hiding it under your mattress. That is not the answer. The answer is the same answer it has always been throughout financial history. Knowledge. The people who survived every banking crisis, every bail-in, every account freeze were not the people who panicked. They were the people who understood exactly how the system worked and positioned themselves accordingly. Number 1. Know your deposit insurance limits and stay within them. In the United States, $250,000 per institution. In the United Kingdom, £85,000 per institution. In the European Union, 100,000 euros per institution. Split deposits across multiple completely separate banks if you exceed these limits. This one step puts you ahead of 90% of ordinary depositors in any banking crisis. Number 2, diversify beyond the banking system entirely. Physical precious metals, real property, productive assets that generate income outside the banking system. Not because banks are evil, but because no single system, however powerful it appears, has ever been permanent, and the people who understood this protected themselves. Number 3, read your bank agreement. I know, it is 47 pages long. It is written in legal language designed to be unreadable, but you do not have to read all 47 pages. You only need to find 4 things: the right of offset clause, the variation clause, the account suspension terms, the force majeure language. Find those 4 sections, understand them, and you will know more about your legal relationship with your bank than 99% of that bank's customers. Here is the thought I want to leave you with. Your bank is not your enemy, but it is also not your friend. It is a business operating within a legal framework designed by people whose primary interest was never your financial security. This video opened your eyes to something your bank never told you. It did exactly what the plain scent was built to do. We do not do comfortable here. We find the truth buried on page 22 and bring it to page 1. Hit that like button right now. Every like tells YouTube that this information deserves to reach more people who need to hear it. Share this with one person who trusts their bank completely and has never read their account agreement. They deserve to know. And if you are not subscribed to the plain scent yet, subscribe right now. The next video goes even deeper into the financial system. You do not want to miss it. The truth is always in the small print. We just help you find it.